Welcome to the second episode of SiGMA World's podcast entitled Decoding Gaming Law in collaboration with CSB Group. Today, very special guest, we have Dr. JP Gauci Maistre, and we'll be talking about gaming litigious matters happening currently in our local courts. Thank you, JP, for being here. Today we'll be speaking about various litigious matters happening in our courts with special focus on gaming companies. So, JP, tell us a bit about you.
So, first and foremost, thank you very much for having me. Great to be here. I think the subjects you want to raise are very important, especially at the moment. I'm a lawyer by profession. I've been practicing for about 15 years now. And I focus predominantly nowadays on corporate matters, corporate law, litigation as well within that sphere, and very much focused recently since 2018, I'd say, on insolvencies, winding up procedures both inside of court, out of court, and everything around that. I basically started my own practice back in 2015. I was practicing before then, independently, but as a firm we set up as GMX in 2015, and it's a partnership with a Greek lawyer as well, so it goes beyond our shores, and that tends to be we're a multidisciplinary firm. We don't do criminal law, but that is my area of focus. So.
Very good. I'm going to jump right in. So what are the predominant litigious matters happening with respect to gaming companies here in Malta?
From a litigation point of view, I'd make a distinction, I think, between, so to speak, the B2B, B2C litigation. Mm-hmm. So on a B2B, we've seen disputes with white labels. Those could be arbitration as well as in court. They tend to push for arbitration for privacy.
And the arbitration works, or?
Arbitration works. Unfortunately, what we experience in arbitration sometimes is that it isn't much swifter than court proceedings. You have lawyers who arbitrate. I'm an arbitrator myself in corporate matters, but what we want to see is a push towards making arbitration more a swifter procedure. Mm-hmm. It's good because it remains confidential. It is costly. It tends to be a bit more costly than the courts of Malta, mm-hmm. the commercial courts. Primarily because it's based on amount, the fees, and you could have 3 arbitrators, depend on your arbitration mm-hmm. clause. So it makes a difference, but there are the pros and cons. Mm-hmm. What I'd like to see in arbitration is that we keep a pace to concluding proceedings.
Because I think the main advantage of arbitration is that it's fast comparison to the courts. But of course, if they're going at the same pace, you might as well go to court.
Exactly. You have mm-hmm. the privacy element over there, but sometimes they prefer swiftness over privacy. Really. So the confidentiality of the proceedings. So we've seen white label disputes over there, wrongful terminations, etc. You get to see debt collection. That's quite big
common
at the moment. Both with affiliates and gaming companies. So we tend to see a bit of that. You get the shareholder disputes. You have what we call the 402 unfair prejudice sort of claims between shareholders. So B2B, you'd get to see a bit more of those, occasionally contractual disputes. And
more or less when it comes to timing, I know it varies depending on the facts and circumstances and different case. But for the most common case to be concluded, how long does it take?
You always have in Malta a couple of years, easily.
Okay.
I mean, a 402 where you've got shareholders disputes is very fact-based. It can drag on. The debt collections tend to be a bit swifter depending on how they're being done. Mm-hmm. We also push for out of court as much as possible.
Exactly.
I mean, at the end of the day, come to a solution. We tend to be mediators, mm-hmm. not in an official role, but as lawyers, we try to mediate to find a solution.
Very good.
And we get that sort of thing with the B2C, where you get the players versus the companies. Then that's why I made a distinction between B2B is more on the corporate level.
Exactly.
And then you get the B2C where you have player claims. which I think has become the talk of the town within the industry for the last few years.
Tell us more about that. So a player who presumably gets a judgment or a decree in a foreign court and would enforce that judgment here in Malta. Can you walk us through a bit?
So what's been happening is, because of the way the legislation has, or so not rather than the legislation, I'd say the case law in predominantly Germany and Austria, but we're seeing other countries now like Holland, where there is an issue with whether the Malta gaming license issued to operators is valid in these jurisdictions. I mean, this warrants a whole conversation,
of course,
in and of itself, and we'd probably need lawyers from different jurisdictions discussing it, and depending how you see it.
But also from a treaty, European treaty point of view, because there's the freedom of establishment and the freedom to provide services.
Exactly.
So if other countries are not recognizing the Maltese license, that could be an impingement on that freedom.
Exactly. So you then enter into a whole world of European law, the fundamentals, the treaties, like you mentioned, but then on the other hand, you have to see what derogations and what laws, local legislation there is in each jurisdiction as well. That's why you need. This would be a whole conversation of different lawyers from different jurisdictions who have different views as well. Depends where you fall. If you fall on the player side or on the operator
side. Sounds much fun.
Yes, for lawyers definitely. Not so much for the operators and the claimants, I think. But what we've seen is, so skipping all of that, there are judgments that are being handed down in European jurisdictions which allow ultimately a player who played with a Malta-based operator and licensed operator in that respective jurisdiction to claim back their losses on the premise that they were operating against the Malta-based operator was operating by infringing the laws of that state, Austria, Germany, etc. Then what they do is that have that judgment. Once they have that judgment in that jurisdiction, they come to Malta and have a lawyer recognize this judgment and enforce it, which tend to be quite swift procedures nowadays because of EU law. So then it's basically the equivalent of having the equivalent of the decision here in Malta, and you can turn on that claimant can turn on the operator here in Malta to enforce their judgment and recover the losses according to judgment. Now, what happened is that obviously there's a massive dispute around this. Malta disagrees with what's going on in other jurisdictions. Lawyers in those jurisdictions disagree what's happening in their own jurisdiction. So,
of course,
it's a lawyer's playground. And there was the introduction of what became known as Bill 55, purely because Bill 55 in our parliament is what brought in an amendment to the Gaming Act.
But it's, even though the term is bill, it's an actual law.
It's no longer a bill. No, it's no longer a bill. It just became
famous for Bill 55.
But it's actually Article 56A of the Gaming Act, so it was an amendment. It is law. And again, in a nutshell, this piece of legislation, this amendment, or this introduction of this article states that on the principle of public policy, any action brought against a Malta gaming operator or any of its directors, past, present, etc., will not be recognized or enforced in Malta.
So the Maltese government, basically Parliament, took a unilateral decision enforcing its right, being a sovereign state, that I will not be recognizing any foreign judgment in this respect.
Exactly.
Specifically for players who lost their
One
funds.
has to be careful here. It's not a blanket article that covers any sort of dispute that will be brought against a gaming operator licensed in Malta or its directors, officers, past and present, because there are the disputes against these companies which are not related to challenging the validity of the license of a Malta game. So one has to be careful not to say that the Parliament of Malta has ring-fenced Malta ordered the courts not to recognize any judgments against gaming operators.
Of course.
So we have to be careful here. It's very specific to these things.
So in practice, I mean, okay, there's a player who has a foreign judgment and sends it to the operator.
Yep.
The operator, what does the operator do? Ignores it?
No, the operators, what the player would do really is get the judgment through their lawyers in Germany, Austria, or wherever it may be. And once they have that judgment, they'll engage a lawyer here in Malta to go to the procedure of recognizing and enforcing it here in Malta. Normally you take out a warrant to try and seize the money of the
garnishee orders and other precautionary warrants. Yes.
So you'd go down that route. Then what the gaming operators are going to do are get their lawyers to step in and challenge that procedure, because that should not be entertained by the court.
Okay.
Again, that's probably the way things in an ideal world would go, and there's the law and it stops there. However, it's easier said than done, because obviously people are bringing challenges to this law. People have been fighting for preliminary references to the ECJ. There are different things where, again, depends where you sit, on which side of the fence you sit. You're going to be arguing either way, either the validity of the law or the non-validity of this article.
And have there been preliminary references published or not yet?
Published, no. There have been no decisions. Again, in and around Bill 55, there hasn't been one specific coming out of Malta. As far as I know, there's been a reference made from a court case in Malta, which has to do with whether the German law is in line with the functioning of the EU, the treaty. Again, this is developing literally week by week. What happened last week is outdated this week, and it's going to continue this for quite some time. What we're hearing is that now there is a preliminary reference probably coming out of Austria with respect to Bill 55. So again, till the websites are updated, you get the information, etc.
Very interesting.
But it's very live, this, and it's changing, and applications are being filed in court to challenge the decrees that the local courts have taken with respect to Bill 55, Article 56A, what type of procedures being used abroad, because again, like we have different procedures here and different tribunals and different courts, same applies for Austria and Germany. It could be a commercial court, it could be an EPO procedure, so this has an impact as well.
Can I ask though, if I'm representing a player, I'm Monty's lawyer representing a player, I need to tell the player, listen, there's this Bill 55 that your claim might be rejected. Do you still want to proceed? And they'd still do it.
Yeah,
it's like an uphill battle, sort of.
Yeah, it's a bit of it's not easy across the board, because you have lawyers abroad who are defending multiple claimants, so there's big money there.
And there's collective action?
It's pretty much collective action,
okay.
Yes. Not necessarily formally so, but they're representing so many players at times that it is essentially that, and all you need is one player out of the entire pool to challenge. On the other hand, operators can't just sit back and say, listen, there's Bill 56, there's Article 56A, we don't need to do anything, because then you end up in a whole different procedural headache of default judgments. If you don't challenge,
exactly,
you're not challenging, so you have to be willing to accept the consequences. So there's a lot of money having to be spent on this litigation.
More work
side
for
of
us.
Thing. More work for lawyers. It's brilliant. But what then the downside, if you had to wear the commercial hat of things, is everyone wants certainty always.
Of
certainty
course.
is what we want as a jurisdiction, what we want as an EU, what business wants. They thrive on certainty.
I think it's human nature as well.
But this is not giving certainty at this point in time. And I think certainty is something we want to drive towards. If you had to look at it, the operators here in Malta, we've got all of different sizes. But the big ones, even the medium size, the small ones, they have plans. That have plans to restructure, to enter new markets, to wind down a company, to shift. Let's say once you have this uncertainty of how to treat these player claims coming in from different jurisdictions, then you start to find it very difficult to plan ahead. And that is where we try to step in, to try and, like I said before, unofficially we'll be mediating, because we want to try and find a solution for both parties. Because if we're on the one hand telling gaming operators you don't need to recognize these claims, but on the other hand a claimant has the right to try and get his claim enforced.
So you can't just ignore
You can't just ignore. So, and this law has given certainty, it is law, and there's a decree on it that, listen, claimants' decisions do not need to be recognized and enforced in Malta. So from an accounting perspective, and I'm speaking very loosely here from accounting because I'm not an accountant, then they don't need to be provided for. So they're not in your books. But at the same time, you can't hide the reality that that claim is there. It could be through court, it could be, it's active.
So from a financial business, if you have a certain amount being claimed, put that amount in, for example, in a reserve or something like that, just to sort of preempt.
Exactly, to account for it, because ultimately you could potentially be falling foul of accounting standards, or you could then find yourself being forced into an insolvent situation. Exactly. At the same time, we have a piece of legislation which says you do not need to recognize these claims. That's black on white, that's the law. So I can't really say I'm in an insolvent position because those claims don't even have to be recognized. So for a company then that wants to restructure, that wants to possibly wind down operations, and people don't wake up in the morning and say, you know what, I'm winding down my operation today. Normally you've thought about it as part of a whole restructuring.
Exactly.
Gaming companies have licenses, they have player funds, they have trademark, they've got a lot of stuff within their group that they need to think about when they restructure. And this then creates a bit of a headache where we will be involved in giving advice, where we know that's the law, but as much as possible we try to find solutions where we see that players really ultimately are willing to negotiate and to settle.
Because also we might need another episode to discuss the solvency proceedings, to be honest. But very high level, you mentioned that there are various factors that you have to take in consideration before going through insolvency. One of them, which I'm thinking, is if they're applying for a license elsewhere, for example, I don't know, Nevada, for example, they would need to declare that one of our companies within the group is insolvent or is going through insolvency proceedings, and they need to assess what are the repercussions of that. So I completely agree with you. That's not just a matter of deciding, okay, let's go insolvent, and end it here.
Yep, and I see it from 2 points as well. I try when you have this situation, I don't know. I can speak from a Malta aspect. You do have to make declarations if you ever were a director or an officer at times of a company that was declared insolvent.
Of course, that's
So again, I just highlight it so that they will know that if they're looking to apply for another license, just to have that at the back of their mind.
Exactly.
Now, currently, these companies, according to decrees of our court and according to law, do not have to take into consideration these player claims. Therefore, they are not insolvent.
Exactly.
So one can say it is a very clear-cut answer, but in reality it is not that clear-cut then, because you're going to see people constantly trying to challenge this law. And as an operator and as a lawyer giving advice to an operator, you say, listen, it's being challenged, let's wait to see the outcome, but that can take a year.
Exactly.
A year is a long time for a business who is trying to restructure and to... So again, I think we try to find that sweet spot of trust is a massive issue in this. And when you get the lawyers representing the claimants and you have the operators, you try to get them to come together and say, let's try to find a solution which works for both of you. And this is not one party trying to tie a noose around the other one's neck or the other one trying to get away.
Exactly.
Let's just find a solution and everyone can be satisfied with that ultimately.
JP, as they say, time flies when you're having fun. And as you said, it's a playground for lawyers. So we're going to conclude today's episode over here. what I think a key takeaway from our discussion is that as much as possible, try to settle out of court. Certainty, and keep an eye on this development, especially with Bill 55, because it's ongoing, it's live, and history is being made.
Yes.
Any concluding remarks from your end?
No, from my end, once again, thank you very much. I really enjoyed this. No, it's exactly like you said, let's try to find certainty and let's negotiate as much as possible. I think that is ultimately the best solution. Don't drag it out because it's time and money. And ultimately operators just want to get down and do their business.
Thank you very much, JP, and thank you for all our listeners.